Hello, good folks, and welcome. We are going to talk about Fani Willis, as it seems she made a boo-boo. During her time as district attorney, people have been in jail, unindicted, some for over a year. And this is something that Bard Business Foundation has taken aim on. Let's check it out. Here we go. In the Superior Court of Fulton County, State of Georgia, Bard Business Foundation, Petitioner, v. Fani T. Willis in her official capacity as Fulton County District Attorney. She is the respondent. Verified petition for writ of mandamus. This is a petition for a writ of mandamus filed on behalf of Bard Business Foundation, hereinafter referred to as Petitioner, to compel Fulton County District Attorney Fani T. Willis, hereinafter referred to as Respondent, to comply with her mandatory public duties under OCGA, paragraph 15-1-5, and Uniform Superior Court Rule 26.3. The rules of this court provide respondent with the following directive. The district attorney shall notify the chief judge in writing of the name of any unindicted accused who have been in custody under criminal felony charges for 45 days within 2 business days after said 45-day period has run. Section 15.1.5 of the Georgia Code further provides that, quote, the rules of the respective courts legally adopted and not in conflict with the Constitution of the United States or of this state, or the laws thereof, are binding and must be observed. Together, these authorities provide a clear public duty that respondent has completely abdicated. To illustrate, during a Superior Court hearing on September 20th, 2023, Senior Assistant District Attorney George Jenkins, the Chief of Respondent's quote-unquote trial division, considered that his office generally does not deal with their obligation to provide notice of delayed indictments under Uniform Superior Court Rule. And when, through counsel, petitioner requested any and all records showing respondents' compliance with this court rule, respondent's office responded, quote, we do not have responsive documents. This, in layman terms, says they can't be bothered in the district attorney's office to follow rule and law in Fulton County, Georgia. Mandamus relief is critical. While the DA's office fails to comply with even this basic requirement to provide notice to this court of unindicted people languishing in custody, the Fulton County Jail is in crisis. Footnote. Unless otherwise indicated, references to the jail refer to the facility at 901 Rice Street, Northwest Atlanta, Georgia. In the face of substantial overcrowding, hundreds of incarcerated people are forced to sleep on the floor. Second footnote. Push to transfer inmates out of state to relieve overcrowding in Fulton County, shot down by judge. 11 alive, October 30th, 2023, and here is the link. Officials sent others to numerous facilities outside Atlanta, placing them hours away from their attorneys and families. Over the last 2 years, at least 24 people have died in Fulton County Sheriff's custody. Those who survive are subject to rampant violence, filthy living quarters, and medical maltreatment. The significant number of people held without indictment at the Fulton County Jail is a major driver of overcrowding and the horrific conditions that follows. Yeah, by the way, if you recall, Fani Willis asked for money to clear the docket, and she chose RICO trials. Said it before, so I will say it again. During the Young Thug RICO trial, between 4 and 8 cases could have been handled per day on average. That means 200 trial days. Then between 800 and 1600 cases could have been tried and solved in that courtroom. Instead, they are doing one RICO trial. A recent analysis indicated that 1,114 individuals, or 37% of the Fulton County Jail population, are held without indictment. Of those unindicted, 503 individuals have been in custody for 90 or more days. Of those 503 people, 207 have been held in jail without indictment for over 6 months. Are you freaking kidding? 207 people in jail without indictment for over 6 months. And why? Well, in my opinion, Fani Willis doesn't win elections with small crimes. That only takes a day or two. She aims to win elections with big, expensive RICO cases that costs taxpayers millions of dollars. My rough estimate, well, if the Young Thug trial concludes within this year of 2024, that will be on the taxpayers a bill of $10 million. Congratulations, Fulton County taxpayers. Enforcing respondents' reporting requirement is necessary to address the Fulton County jail crisis. The Uniform Court rules require respondent to inform the chief judge when an incarcerated person has been detained on felony charges for 45 days without indictment. So the chief judge may take any action deemed necessary or appropriate under the circumstances. Given the dire circumstances, Rule 26.3 is now especially critical so that the chief judge has notice of who and how many people are stuck unindicted in the overcrowded and dangerous jail, and can take necessary and appropriate actions to prevent individuals from languishing in detention for months. Georgia, this rule. This court has at its disposal a number of mechanisms to remedy these issues. Responsible for overseeing the court's administration, the chief judge is empowered to. Folks, take a wild guess on who chief judge is. You are correct. That is Judge Glanville, who is the presiding judge over the Young Thug RICO trial, where he, in my opinion, is a part of the prosecution team. Do what you want with that information. Here we are. Implement practices and issue standing orders that regulate the internal process of the court. Make a written request for assistance from other judges and instruct magistrate judges to consistently evaluate cases for probable cause within 3 days of arrest. These are all actions that could be used to process cases in a timely way and to drastically reduce the jail population. But the chief judge cannot craft and implement a necessary and an appropriate response without respondent Fani Willis providing an accurate and regular assessment of the pre-indictment population. Petitioner requests that this court issue a writ of mandamus compelling respondent to comply with their public duty and notify the chief judge in writing of the names of any and all unindicted accused persons who have been in Fulton County custody under criminal felony charges for 45 or more days. In support of this verified petition for writ of mandamus, petitioner show this honorable court the following. Petitioner, Bard Business Foundation, is a non-profit organization whose mission is to provide justice impacted people with guidance and assistance to give them opportunities to establish their lives and gain financial independence through providing supportive services, education, job skill training, life skills, and case management. Its office is located in Fulton County. Respondent Fani Willis is the district attorney for Fulton County, Georgia. Respondent is named in her official capacity and is the subject of the jurisdiction and venue of this court. 3. This court has jurisdiction to issue a writ of mandamus under this paragraph. 4. Respondent has a clear legal duty under this paragraph and Uniform Superior Court Rule 26.3. On September 20th, 2023, Senior Assistant District Attorney George Jenkins admitted in open court that the office usually does not fulfill its obligations under Uniform Superior Court Rule 26.3. Could that be because they don't give a damn? Could that be because Fani Willis is busy either going on holidays with her boyfriend / special prosecutor, apparently now ex-boyfriend, or having RICO trials which is in the way for prosecuting real crimes? Every day the Young Thug trial moves on is a day when between 4 and 8 defendants won't have their day in court. Between 4 and 8 victims won't get justice, in my opinion. On December 4th, 2023, Counsel for Petitioner issued a request to Respondent's Office through the Open Records Act, seeking, inter alia, all internal directives, policies, or other materials regarding the manner in which Respondent notifies Chief Judge in writing the names of unindicted people who has been in custody for 45 days. Petitioner's Counsel's first open records request to the Fulton County District Attorney's Office. See that exhibit. In response, on December 19th, which is a good while later, Respondent's Office replied, "We do not have responsive documents." That means they don't have any SOPs, standard operational procedures. They don't have the rules written down, how to conduct it, who is responsible, who can do it. Nothing. Because I assume Fani Willis don't care, because she's a political being who doesn't give 2 shits on a straw about justice. Sue me, Miss Willis. I would love to have discovery on every piece of data you own. On December 24th, 2023, Counsel for Petitioner issued a request to the Respondent's Office through the Open Records Act, seeking records from October 1st, 2023 through December 22nd, 2023, related to any notification Respondent provided the Chief Judge regarding unindicted people who have been in custody for 45 days. In response, December 28, 2023, Respondent's Office replied, "We do not have responsive documents." So during the time period of October 1st and December 22nd, they did never notify Chief Judge about people being unindicted in jail for more than 45 days. Respondent has announced that her office will not indict individuals unless, in her subjective assessments, they are trial ready. Seriously, Ms. Willis? Until they are trial ready? Oh, her office isn't trial ready. Here's the thing, Miss Willis. If you drag your feet, if you're too busy going down on Mr. Wade or going to Aruba, or if you have a new boyfriend who you spread eagle to, do it on your spare time. Do your fucking job as a district attorney. You're elected for it, Miss Willis. Respondent's refusal to comply with the Uniform Superior Court rule prevents the Chief Judge from fulfilling his supervisory role in preventing unjustified pre-indictment delay, and subsequently contributes to extended case processing and jail overcrowding. Maybe Miss Willis wants people to die in jail. Who knows? It's pure speculation. All we know is that she doesn't give two shits on a straw about the rules. And we also know that through her conduct in the disqualification case against her. Whereas here, a public official has refused to comply with the mandatory public duty, a writ of mandamus is appropriate. Quote, 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 quote. Additionally, accordingly, Petitioner seeks a writ of mandamus requiring respondents to comply with their duty to comply with the public duty and notify the Chief Judge in writing of the names of any and all indicted accused persons who have been in Fulton County custody under felony charges for 45 or more days. Jesus Christ, this is 44 pages long. I just saw that. All right, here we go. Petitioner has no other specific legal remedy for respondent's violation of her public duty. This petition concerns one of public rights whose object is to procure the enforcement of a public duty. Petitioner is interested in having the laws executed and the duty in question enforced, and need not show any legal or special interest. Mandamus is further appropriate here because it would not be nugatory or fruitless. First, by notifying the Chief Judge of the people who remain in custody unindicted for 45 days, the Chief Judge can take any actions deemed necessary or appropriate under the circumstances to expedite case processing and resolution. Second, by bringing her office into compliance with a public duty under Uniform Superior Court Rule 26.3 and maintaining compliance, respondent is likely to identify cases ripe for dismissal, plea bargain, or other disposition. I would, thinking back on the Young Thug case, where they spent a year and a half in jail, many people did take plea deals or plea bargains just because they were in there. So it seems to be a tactics for Miss Willis to put people in jail and leave them there and do shit all until they accept a plea deal. Together, these actions will facilitate reasonable timelines for indictment and consequently reduce the dangerous overcrowding in the Fulton County Jail. They will also alleviate the cost of the Fulton County Sheriff's Office and the public of needlessly detaining individuals when detention serves neither the ends of justice nor the public interest. Yeah, if you didn't know, having a person in jail costs money. Yeah, if you thought it was free, well, sort of. If free means taxpayers' money. Wherefore, Petitioner respectfully requests that this court issue a mandamus nisi proposed order attached hereto as soon as practicable, directing respondents to appear before this court within not less than 10 or more than 30 days as required by the OCGA, and show cause why a writ of mandamus should not be granted, ordering respondent to comply with their public duty and notify the chief judge in writing of the names of any and all unindicted accused persons who have been in Fulton County custody under criminal felony charges for 45 or more days. Petitioner also requests such other and further relief as may be just and proper, including attorney's fees. Yeah, writing this to the court, it costs money. Respectfully submitted, Julian Clark, Brandon Busky, American Civil Liberties Union Foundation, Criminal Law Reform Project, Andres Lopez Delgado, Corey Isaacson. These are the attorneys for the petitioner. Pro hac vice application forthcoming. Verification, okay. And this is the mandamus nisi they are proposing. The petition of Petitioner, Bard Business Foundation, is the above captioned case have been read and considered. Having been read and considered, the same is hereby sanctioned and ordered filed. As is further ordered that respondent, Fulton County District Attorney Fani Willis, appear before me, as in the judge, at the courthouse in the city of Atlanta, Georgia, on this day. So this is just their suggestion for the judge to just, looks good, signing it, boom, done. Exhibit A, transcript of September 20th, 2023 Superior Court hearing. Exhibit A, transcript of motion hearings before the Honorable Ural D. Glanville, held on September 20th, 2023. Appearance for counsel, George Jenkins, for the defendant, Susan Tevis. The court. Good afternoon, counsels, interested parties. We are here on the record in the matter of the state of Georgia v. Jasper Walters. Let's see if this is the one I am looking for. Yep, this is the one I'm looking for. Pay attention here. In indictment, blah, blah, blah. This motion was filed by the defendant's attorney, Ms. Suzanne Tevis, and we are here today to take up this particular motion under Superior Court Rule 26.3. Good afternoon, Mr. Jenkins, and good afternoon, Ms. Tevis, and good afternoon, Mr. Walters. Counsels, I understand that you all, prior to the court calling this case formally in open court, were arranging for your client to be here via Zoom. Is that satisfactory to you, Ms. Tevis? Yes, Your Honor. The court. Okay, I just want to make sure. You all had opportunity to chat. Is that correct, Mr. Jenkins? Briefly, Your Honor. Absolutely. The court. Can you summarize for the record, if you wish, or are desirous of doing that, what your discussions have been in regard to Mr. Walters? Mr. Jenkins. Yes, Your Honor. May I approach the podium? You may, sir. Briefly, Judge. Ms. Tevis and I briefly spoke, and I'm here on behalf of the state, George Jenkins, and in addition, the supervisor of the division in charging, because this matter has not formally been indicted as of yet, Judge. The appropriate case number is this. And essentially, Ms. Tevis has been trying to get the attention of our office in connection with some of the underlying matters of facts and circumstances regarding this warrant, in this case, charging Mr. Walters with aggravated assault against a police officer, and I do believe obstruction of a law enforcement officer, Judge. Aggravated assault against a police officer and obstruction of a law enforcement officer. That could be, I've seen all the YouTube videos. That could be, stop, no, get over here, no. I don't know. I have no idea. And I don't care. And so she filed these motions on the 18th of September. There are two motions judged before this court, one under 26, Uniform Superior Court Code 26.3. And then essentially what she's filed is a pre-indictment Franks hearing motion in the second motion, both filed on the same day, at the same time, alleging there are some representations by the officer in the warrant itself and his testimony regarding the preliminary hearing in this matter. So the state formally would request 10 days for a hearing to set regarding this matter specifically, Judge. However, a part of our conversation, I did have an opportunity briefly reading the motion in both of these matters presented by Ms. Tevis in this case. I did speak with Ed Hutcherson, who is the supervisor and managing attorney over our charging division. I spoke with him. He has also had an opportunity to briefly review the motion in connection with the misrepresentation, the Franks hearing essentially. And he said to me that he will make a decision in connection with this case in terms of charging by this Friday. And that would be the 22nd, whether or not to charge or not to charge. Something tells me they chose not to. We are aware of some of the allegations made by defense counsel in this case, and they need to be vetted specifically. I do, and I am aware that Ms. Tevis has for some time been trying to get in contact and get traction from our office in connection with this matter, and was, I guess, forced or decided to file these motions. She has our attention, Judge, and we will do that. Now, as for the motion regarding under 26.3, we do apologize to the court for not specifically alerting you to the fact, Judge, and we don't generally deal with this superior court rule, but not alerting you after 45 days. The defendant has been in custody, that no indictment can be sought up until this point in time regarding this defendant. He's been in custody over a year. This man has been in jail for over a year for a scuffle with a cop. Let's say that, a scuffle with a cop. He's been in custody over a year in connection to this specific case. Now, he's had some other matters, I don't know if the court is aware, he's been dealing with that put him in the custody of the Fulton County Jail. However, I just want to remind the court that certainly, and while we understand and we apologize, the defendant is charged with certain felonies. We have the statutory period, which is 4 years, to formally charge this case. Yeah. Formally charged. That is the statute of limitations. I don't think that was intended to put people in jail for that amount of time. As it seems, they are trying. And the allegation in this matter is that it occurred on March 6 of 2021. We are under the tolling period in connection with the CVID during that period of time under the former Chief Judge Brasher. Remember, Ms. Fani Willis, District Attorney Fani Willis, asked and got a huge chunk of cash to clear the docket of cases that accumulated during the CVID. She used that money for a handful of RICO cases instead of up to 20,000 cases currently waiting in the docket. And that is not all of them. You have a ton of unindicted on top of that number. And so essentially the statutory period would run officially, I do believe, at least of March of 2025. And then you have the tolling period There is probably an additional 90 days on that. So we are looking at June of 2025 as to when the statute runs in terms of our ability to charge. I really don't think the statute of limitations are there for you to keep people in jail until the statute of limitations run out. I really don't think that's what it's there for. However, we are aware, as I said before, Judge, of the circumstances and allegations that defense counsel made in this case, and Mr. Hutchinson is going to vet that and will make a decision by this Friday. So that's our position. We did speak briefly about that, and I let Ms. Tevis speak to this matter. If you want to have a formal hearing, we're asking for 10 days. However, I think a decision will be made, a decision will be made by Friday the 22nd in this matter in terms of charge or not charge. And defense counsel and this court now have the state's position, and that is our request at the time, Judge. Thank you. The court. Judge Glanville. Okay, I've had a chance to take a look at Ms. Tevis' motion, and what I'll hear from her, but I think that her prayer for relief is that she's properly under 26.3 brought to this court's attention in my role as chief judge. And given some of the things that are outstanding, some of them which I know that our elected district attorney is certainly working on, apparently she is not working on it. And it asks for you all to provide a list of the unindicted persons as required under the rule, and that is 26.3, and ask me to specifically address Mr. Walters' case, and then set up status and scheduling orders for other unindicted cases over a certain time period, and provide any other relief that the court deems necessary. About a month later, this judge sat down for the Young Thug RICO case. Yeah. Based on his conduct in that trial, I don't think he cares as well. So before we leave here, I will go ahead and set at least 10 days, hence to at least take up some of the other things. And then you all can kind of keep me posted on your progress or whatever on other things. I would ordinarily, you are correct, Mr. Jenkins, not get involved with this. Say what now? Mr. Glanville, you're the chief judge. This is your responsibility according to Georgia rules. But I understand why. I'm not annoyed. I'm not upset. I just, like everyone, I think that, we're all trying to figure out a way to kind of make sure that the perception and reality of justice is followed. And I know everybody's working hard. Oh, I don't think so. I don't think Fani Willis cares. She has an election to win. She has RICO cases to run. That's all she cares about. Besides finding a new man to go to Aruba with now that her Mr. Wade is out and about. So here for Ms. Tevis, and that will be the court's plan after that. Mr. Jenkins, thank you, Judge. The court. Ms. Tevis, Madam. Ms. Tevis, thank you, Your Honor. And just thank you to everyone for scheduling this so fast. Yeah, I will be brief because I think everything has generally been covered. As far as Mr. Walters goes, having a decision by Friday would be wonderful. Is that acceptable? The court says, is that acceptable to you and your client? Ms. Tevis, that is, we always maintained his innocence in this, but if it's going to be indicted, we would like something to happen with the case because he's been stuck in this limbo for over a year. We can't do anything with the case. So if something's going to happen, we ask it for happen so we can move forward one way or another. But as somebody, as Your Honor knows, who has practiced in this jurisdiction for a long time, same as Your Honor, Mr. Jenkins has been here. It's hard to watch all the things that have been happening and not want to try to address it somehow. And I thought this was a good vehicle to bring it to you. I know you're someone who will do something and someone who cares about all the things that are going on, same as Mr. Jenkins. Yeah. And I just thought, to me, something that has been very different about things in Fulton County from years ago as they are now is we used to do more about tracking with the unindicted cases. So this more or less started as soon as Miss Willis took office in 2021. The misconduct started immediately. She's a good, decent politician, but as a district attorney, she's incompetent, in my opinion. And I know we had a disease thingy and things have happened. There has been a lot of changes. But to me, it seems one of the things that we could do is a better job of tracking these unindicted cases so they aren't falling through the cracks, so that we aren't a year later saying what's going on. Because in practice, what happens is we talk to our clients and they say, well, what's going to happen? When's my next court date? And we don't have anything to tell them. And it's like, well, maybe I can file a bond motion. Maybe you have a bond motion at some point. And there's nothing really to tell people. And I just think that one simple fix of having some type of scheduling order, something like that would help. And I think it would help keep everything on track so things don't fall through the cracks. Understanding that the DA's office may say, well, this might take longer. We're doing this X, Y, and Z. That's what would happen. But it used to be that cases would come before the judge every 4 weeks and so on, say, these are unindicted cases and what's taking so long and something like that. And that's why I went ahead and asked for that in the relief, because I think that's something Your Honor could do. And I think that would help address some of the backlog going on, perhaps the overcrowding at the jail, if we started maybe addressing those underlying issues. Yeah, maybe not have a unnecessary RICO trials going on would give relief to the jail, relief to the court, relief to the victims and the defendants who deserve their day in court. Just maybe. Folks, yeah, okay. So that's why I included that here, and hopefully maybe that is something that we can address, some of the overall issues that has been going on in Fulton County. Otherwise, I basically agree with everything else that's been said. So again, thank you for scheduling us so fast. And just so Mr. Walters know, this all just happened today, so it's not like I didn't tell you. So I know you were surprised as well. So thank you all very much. The court. All right, Ms. Tevis, let me comment on a couple of things that you raised. I am familiar with, I know that our district attorney and her staff and team are culling through a lot of the unindicted matters. Fuck no. Nuh-uh. No, they don't. No, they don't. Because if they did, remember the papers, the documents a few minutes ago? There are nothing documented about the district attorney's office doing anything. I participate in a monthly update on the progress that all of us as justice partners are making, and it's a lot. So where's those documents, Judge Glanville? If the district attorney have nothing to give to the petitioner, what's going on with those meetings? Why aren't they recorded? Huh? Having said that, of course, I also am familiar that or aware that Mr. Kenner and people from your team and people from Ms. Willis' team meet weekly to kind of go through the cases that you believe can be resolved or unindicted or whatever. They come in different categories. That would be the public defender's office and the district attorney's office, who meet regularly. Are there any plea deals? Not uncommon, but apparently The district attorney's office simply don't care, in my opinion, as it seems by the facts alleged in this. And I think to that extent as well, we're going to try Saturday court at the end of the month to see if we can move some more cases. I know that my colleague Judge McBurney has volunteered to sit and participate in that. Yeah, Saturday court. Yeah, that's not fun. Here's another idea. You take the Young Thug RICO case and do a motion of off you fuck. This is crap. Off you fuck. Look at all the time we freed up so we can do all the indictments and charges and everything. How about that? Huh? So, I mean, this is another vehicle. I don't have any issues with it, but, part of the challenge is that some of these folks may fall into other categories that need to be dealt with individually. So I think that Mr. Jenkins has told you that he's going to go ahead and deal with. He and Mr. Hutchison are going to deal with Mr. Walters by Friday. There will be a charging decision one way or the other. Apparently not. The other folks, my suggestion is that when I set this date for you all to come back, that you use that as a date, a kind of benchmark to say, okay, here's the people that we think that we can kind of address, and then, tell me what your plan is. No, Judge. The district attorney shows up to you with a list, and then you make the decisions how to address all of that. Why do you want what I assume is the defense team, the public defenders office? Why do you want them to come up with ideas? This is your responsibility, Judge Glanville. Next line here. But I'm going to leave you all to do the heavy lifting because that's where it lies. I can provide you a forum and some accountability, but understanding there are a lot of other factors that I don't control because I'm the referee. This is Judge Glanville. This is not about how to get people to court as soon as possible. This is the district attorney providing you with a list so you, Mr. Glanville, Judge Glanville, make necessary remedies. And now here you are telling prosecutor, defense, you do it. You do it. I can't be bothered. But I can go ahead and at least pursuant to this Rule 26.3 kind of just inquire. I can inquire. No shit, Sherlock. And I think that will, as we say in the military, that as a forcing function, that's fine. I don't have an issue with that. Apparently you have lots of issues with this, in my opinion. So, Mr. Jenkins, is that acceptable to you, sir? Mr. Jenkins, it is, Your Honor, the court. For you all to look at those, in addition to Mr. Walters, just look at that particular universe along with your team and just kind of let me know what I can do to help out. How about do your fucking job, Judge Glanville? Mr. Jenkins, absolutely, Judge. The court, and to that extent, Ms. Willis has reached out as well and has screened several hundred people that are bond eligible, and she's going to grant or agree to have bond, I should say, too. Really? 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 With what I've learned during the cases in Fulton County, I either cover or know about, she don't give bond to anyone. She wants these people in jail without bond. So, judge claiming this, I don't buy it. Let's continue. So I know that some things are happening. Ms. Tevis, and I don't have any issue with you bringing this to my attention. And I will mark your motion as Court 1 for purposes of the hearing. And like I said, I let the state formally respond. And that date, and then they are talking about date between court and Mr. Jenkins. And then between the court and Mr. Walters. The court. Mr. Walters, can you hear me? The defendant, I can. The court. Do you have any questions? No. Proceedings concluded. And here is court's exhibit. Motion for hearing with Chief Judge regarding delayed indictment under Rule 26.3. Rule 26.3 states, the district attorney shall notify the chief judge in writing of the name of any unindicted accused who has been in custody under criminal felony charges for 45 days within 2 business days after said 45-day period has run. The chief judge may take any action deemed necessary and or appropriate under the circumstances. And Judge Lavin's decision was, you do it. I can't be bothered. You do it. At the time of this motion, Mr. Jasper Walters has been in the Fulton County Jail for 434 days without indictment. Mr. Walters is stuck unindicted, and there apparently is not even an assistant district attorney who is working on his case, despite the fact he has been in custody on this matter for more than a year. In May of 2023, at a hearing for another case for Mr. Walters, a Fulton County ADA announced in open court that this case was on track to be indicted. When defense counsel inquired to where that ADA got that information, that ADA told her that 3 other ADAs told her that, but she would not give defense counsel any of those names when requested. Delay tactics by lying to the court, perhaps. What's a little lie to the court when you're assistant district attorney? We've seen it. That conversation in court occurred more than 4 months ago, and the posture of this case remains unchanged. In August 2023, defense counsel communicated with a different Fulton County ADA about a potential bond hearing for Mr. Walters. That ADA said it did not seem as though the case was assigned to anyone in the complaint room. And he said that he was only going to be prepared for a bond hearing. He did not know about the actual merits or the status of the case. What in God's name is going on in the district attorney's office? Are they just sitting around circle jerking? I don't know. Or are they all focused on 5 RICO cases? Maybe both. I don't know. On August 4th, 2023, defense counsel emailed the head of the intake unit, Executive District Attorney Kenneth Hutchison, directly to ask for a meeting about this case. As of the date of this filing, there has been no response. On August 21st, 2023, defense counsel again emailed Deputy Hutchison, and this time copied Madam District Attorney Fani Willis. Defense counsel understands how unbelievably busy the other parties are, but again, there has been no response. On August 24th, On August 24th, 2023, defense counsel again emailed those parties and asked if her emails were going through. Again, there's been no response as of the time of this filing. Sorry. Do I need to edit that out? Nah. You guys, you're used to me doing stuff live, so why not have a On August 24th, the defense counsel again emailed those parties and asked if her emails was going through. Again, there's been no response as of the time of this filing. Many eyes have been on Fulton County as former president was recently charged along with 18 other people in a RICO indictment. 17 of those people were able to contact the Fulton County District Attorney's Office and quickly obtained a consent bond for their clients so that their clients were able to bond in and out quickly from the jail. How about that? Yet Mr. Walters has been sitting in the Fulton County Jail for over a year and his counsel is unable to find a single ADA who can actually talk to her about the merits of this case. Is it because Mr. Walters has a bubbling defender? Is it because he's not on the Trump RICO case or other high-level case? Footnote. It is worth noting that defense counsel can get responses from the ADAs in the specialty divisions, major cases, crimes. The problem seems to be these trial division cases. At this point, it is hard to understand why Mr. Walters has been sitting unindicted for over a year while his attorney's emails go unanswered and while it seems his case is not being worked on. The DA's summer booklet talks about how the way cases are prosecuted at the DA's office has transformed. Quote, the past administration would pursue an indictment with little to no investigation into cases. Through the inception of the case intake division, the flawed process has come to an end. End quote. Well, it seems like a lot of things came to an end, like actual work in the district attorney's office. This certainly is admirable, but this cannot mean, or at least should not mean, that defendants just sit in jail while nothing is being done on their cases. Defense counsel believes she is ineffective if she continues to sit back idly as her clients sit in custody day by day, unindicted, and at this point, she cannot even figure out who to contact for the state. Mr. Walters has waited patiently for a long time on the very charge for which another person was arrested. What? Footnote. Originally, the investigator from the case took out a warrant for another individual after the victim positively identified that individual as the person who committed the assault. Was that individual provided an alibi? That individual was released from the custody, and months later, a warrant was taken out for Mr. Walters. To date, there has never been any identification made of Mr. Walters as the perpetrator of this crime, and in fact, the driver of the car would state that Mr. Walters was not the passenger of the car. Seriously? Seriously? He's been in jail for over a year for a crime. There's no eyewitness, and the driver of the car states that Mr. Walters was not the passenger. So he's in jail for nothing for over a year. Considering the circumstances, Superior Court Rule 26.3 gives the Chief Judge the power to step in, and Mr. Walters is begging for that here. Mr. Walters is asking for a status hearing so that his case can either proceed forward or not. He maintains his innocence, but this limbo that the state is keeping him in is a violation of his due process and constitutional rights. And he is not alone in this. I mean, in Europe, we can hold people in jail up until trial without a charge. But that's our way. We have, for instance, in Sweden, we have 4 levels of reasonable suspicion of a crime, where one is that it happened a crime, somebody did it. Second stage, we have a suspect. Now we can investigate. Third level, okay, search warrant, bring him in jail. Fourth level, we are ready for trial. We can't just hold them in jail without prosecution, going to the court on regular basis and say, we are moving along with this case, gives examples, and then the court says, okay, this man will or woman will remain in jail due to this and this. But sometimes the court says, well, you have come so far along that this person can no longer, we don't deem him or her as a violent person, or they can no longer destroy evidence or intimidate witnesses. They cannot flee the country. So they can actually be let go, waiting for trial by the court. Here, Ms. Willis seems to solve this problem with not doing anything, because if she does jack squat, then court doesn't have to know about it, apparently. As according to a recent article, of the 3,600 people being held pre-trial at the jail, only 36% have had their cases indicted. Even if that number is off, common sense and experience tells us that there is a problem with unindicted cases at the jail. Many of the inmates who have died recently were being held on unindicted cases. So, constitutionally, innocent people in jail ended up dead. And the prosecution's office still does nothing. Having the list, as required under Rule 26.3, will help with tracking. Further, there is a real need for the court to step in and put a scheduling order in place so that these unindicted cases do not continue to end up lost in the system. Yeah. Bring them to court. Have the prosecution says, this is our case. Judge. The defense says, no, it isn't. Judge, either indict the man or let him go. Boom. Done. But why listen to me? I'm practical. I have a sense of logic. And I have a conscience. And I have morals. Things that Fani Willis is in complete lack of. Morals. Thankfully, these numbers have improved post-pandemic. In fact, in the summer booklet, the DA's office proclaimed 100% of all unindicted case backlog from previous administration cleared. The previous administration was up until December 31st, 2020. Then what? This booklet also said 80% of all cases received by the office in 2021 have been processed by charging. 60% of all cases received in 2022 have been indicted or dismissed. The case intake division is on track to clear all 2021 cases this fall and all 2022 cases this winter. Yeah, I would really like to... Are those general claims, or do they have actual numbers to back them up with? And considering the level of evidence presentations from this district attorney's office, I think it's word vomit. But they can prove me wrong. Considering the totality of the circumstances, Mr. Walters moves this court to set a date for hearing, where the district attorney's office can provide the list of unindicted inmates as required, where the district attorney's office can address the status of Mr. Walters' case and explain what has been done on his case in the last year that he's been in custody, where the court can set status hearings and scheduling orders for other jail unindicted cases over a certain amount to cut time and provide any other relief the court deems necessary. This was September 18th, 2023. And then it kept going and going. But remember, this is, if you look up here on the right hand, March 14th, 2024. And Mr. Walters is apparently still in jail. Judge Glanville has done fuck all. Fani Willis has done nothing, in my opinion. There seems to be a lot of people in the district attorney's office just collecting salaries. And that's unnerving to read about something like this when people in the United States of America can sit unindicted for over a year because the district attorney's office doesn't even investigate it. There should be brought up to the judge, Glanville, where they need to have a full declaration. On this date we did this, on this date we did that, to see the progress of the case. Now, if nothing has been done for the full year, Mr. Walters has been in jail. He should be compensated. Now, I know he won't, because it will be a whoopsie, off you fuck. But this is, in my opinion, one other thing that tells me that Fani Willis is unsuited for her position. She's morally corrupt. She's done legally very questionable things. And she's getting away with it, apparently. All right, folks. Thank you for listening. Until next time, hug your family. Unless your family is shit, then fuck them and give your love to the people who deserve it. Bye-bye.